Hello students. Be ready for the dictation. Start. 24 On the doctrine of promissory estoppel. Since it is an equitable doctrine, it only comes into play when equity requires a party be estopped from withdrawing its promise. It has been well settled by this court in several judgments that the principle of promissory estoppel cannot be invoked against the exercise of legislative power. In order to avoid burden on the present judgment, we are relying on the observations made by this court in a recent judgment dealing with the doctrine of promissory estoppel. The bench in Hero Motocorp Limited versus Union of India 2023 1 SCC 386, while relying upon other judgments of this court, in this regard, observed that a common thread in all these judgments that could be noticed is that all these judgments consistently hold that there can be no estoppel against the legislature in the exercise of its legislative functions. The Constitution Bench, in the case of M. Ramnatha Pillai, Supra, has approved the view in American jurisprudence that the doctrine of estoppel will not be applied against the state in its governmental, public or sovereign capacity. It further held that the only exception with regard to applicability of the doctrine of estoppel is where it is necessary to prevent fraud or manifest injustice. The analysis of all the judgments of this court on the issue would reveal that it is a consistent view of this court, reiterated again in Godfrey Phillips India Limited, Supra, that there can be no promissory estoppel against the legislature in the exercise of its legislative functions. In the light of the observations made by this court in the above cited judgments and several others, it is an evident position of law that a prior executive decision does not bar the state legislature from enacting a law or framing any policy contrary to or in conflict with the previous executive decision in furtherance of larger public interest. Nor can it be canvassed that the law laid down by the legislature would be hit by principle of promissory estoppel or legitimate expectation, because earlier the executive had expressed its view differently. Para change. 25. Now coming to the next submission on behalf of the appellants with regard to the question as to whether the concession agreement is a lease or a bond or a license. The definition of lease as given under the Act clearly covers any instrument by which tolls of any description are let, and also under Section 105 of the TP Act, all the ingredients of a lease are fulfilled. In the present case, we need not reiterate and repeat the same reasoning and findings as given by the High Court in great detail after considering the various clauses of the concession agreement. We uphold the finding of the High Court to be clearly justified and based upon a clear understanding of the terms of the concession agreement. We do not find any perversity at all in the reasoning given by the High Court to uphold the concession agreement to be a lease. In situations such as the one before us, if the previous executive decision is withdrawn, modified or amended in any manner in exercise of legislative power in larger public interest, then the earlier promise upon which the party acts cannot be enforced as a right, and neither can the authorities be estopped from withdrawing its promise, as such an expectation does not give any enforceable right to the party. Thank you, students. Over.